All right, welcome everybody. I'm attorney Justin Randall with Hooper Law Office. Our topic today is on maintaining control over your care after you've gone into an assisted living or skilled nursing facility, some sort of facility outside of the home. So if you were listening in on our discussion last week, which was about maintaining control of care at home, some of this will overlap a little bit because some of it's just generally good advice for when care is needed, or really when you're concerned about maybe declines in health or capacity or anything like that. So some of it, if you listened last week, might sound a little repetitive, but that's because it's just good information to have. But some of it will be more geared towards the actual care in a facility as well. And just as always with these webinars, you'll receive at the end of this a couple of things from us. Our handout on planning for the family home or cabin property, real estate in general. It's a good handout on things that you should be aware of when you're looking at somebody possibly needing care. Good and bad options, for example. And I'll touch on those a little bit today as well. But then you'll also receive a feedback form from us through that email as well, which gives you a place to, of course, give us feedback on things. But also, if you'd like us to reach out to you after hearing me speak today, in order to set aside time to talk to you or your family about planning for a loved one, or just estate planning or elder law in general, of course, please feel free to fill that out. That lets us know that we can reach out to you and set aside time. We do set those up for about 2 hours. They are complimentary initial consultations, and we do ask for some financial information as well, which really gives us like statements and things like that, which will really help us sort of diagnose the situation a little bit more accurately than if we don't have all of that information. So if you are interested in that, please feel free to fill that out and send that back to us. We'll be more than happy to set aside time and talk with you. And our topic next week, sort of shifting gears from the care, planning around care, is very timely given that this weekend is Labor Day or Labor Day weekend. I always get those two mixed up in my head for whatever reason. Labor Day weekend is coming up. And so a lot of people go to their family lake homes, cottages, up north properties, right? And as we all know in the Midwest, up north is just completely relative to where you are and also wherever your property is. Up north can be down south if that's where your family property is. So we'll be talking about planning for those properties and passing that on to the next generation next week. But okay. And one other thing before I forget is if you have questions during this, you can submit them to the Q&A function and I can see them come up. So if you have questions, please feel free to ask them and I will ask or answer those questions as they come up. But okay, so anyway, to get started, today, like I said, we're talking about maintaining control over your care options or your loved one's care options in a facility or in a care facility. So, a lot of the things, like I mentioned, that you want to do in general when we're talking about maintaining control over your care options, whether it's at home or in a facility, are very similar and in some cases identical to what you would want to do in either situation. And a perfect example of that is making sure that you or your loved ones have good powers of attorney in place, both financial and healthcare. Or if they don't have them in place, make sure they get some documents in place so that you can step in and help them if they lose capacity for any reason. Without good powers of attorney, and what I mean by good powers of attorney is making sure they actually have the authorities you need included in them. Powers of attorney are not all created the same. It's very dependent on what authorities it actually authorizes in that document. So the state statutory form, while better than nothing, is not going to be as good as one that you've had drafted for you for your specific needs by an attorney who maybe practices in the area of elder law in particular, because they're going to include authorities in there, both financial and healthcare, that relate specifically to decisions that would need to be made around that. The state statutory form, the initial next to these powers that you want to grant, doesn't include a lot of the authorities that we would need someone to have. So by having good powers of attorney, I don't just mean having them in general, but also making sure they have the authorities that you need in there so that your loved ones can step in. In terms of having financial and healthcare, you want both, obviously, because there are different types of decisions that need to be made. And although going into care sounds like primarily a healthcare decision because that's healthcare being provided. That's a big chunk of it, of course, but there's also the financial component over care. Care is expensive. It's not it's not covered by things permanently anyway. It's not covered long term by things like Medicare. So knowing that you have a good financial power of attorney in place so that your loved one can do planning for you, or so you can do planning for your loved one, depending on which side of this you're coming at it from, is really important, because if you have the options in that financial power of attorney to do financial planning, to make sure that they're protected, their assets are protected from having to spend down to nothing, those sorts of options are important to have available to you. So if powers of attorney aren't in place for this, the individual, make sure they get those documents in place while they still have capacity. If they don't have capacity at this point and are not able to sign these documents, the only option available for those people is to go through guardianship if they don't have powers of attorney in place. So guardianship can be necessary at certain times for certain people. I don't mean to say it's worse from it's like the end of the world if somebody has to go through guardianship, if that's the only option they have. But there are powers in a financial power of attorney in particular that you can grant to your financial power of attorney agent that a guardianship court is almost certainly not going to grant. Not because they're illegal, but because they're just not things they feel comfortable granting or that would be in the interest of the state to grant, right? Things related to planning around long-term care, for example. Even things like, can we set up what's called a pooled supplemental needs trust, which, if you're unfamiliar, just means setting aside money in this trust that then doesn't count against you for Medicaid, but qualification, but then there's recovery by the state at the end of that person's life for what Medicaid paid. So the state gets its money back, that it's paid from that that supplemental needs trust, pooled supplemental needs trust, if it needs it. But even then, I've heard that it's very difficult where people have had trouble getting that authority through the guardianship. And it's not something I have heard myself directly, because we generally have good powers of attorney in place for our clients where we're not worried about that. But from other elder law attorneys, I've heard it can be very difficult to get that in place. So having good powers of attorney are very important. Make sure you talk to someone who primarily practices in estate planning or elder law, or a combination of the two. Just like I shouldn't be giving in-depth advice on divorce, divorce attorneys shouldn't be giving in-depth advice on estate planning documents, right? It's just not, it's a different skill set, different knowledge base. So, so good powers of attorney are essential, but in terms of how do we maintain control over care the most, it often comes down to finances, right? As with a lot of things in life, it's very much so based off of what can you afford, what can you privately pay for, how long can you do that? Maintaining control is very much so tied to how your ability to privately pay. Maintaining control of which facilities you can go to, what types of amenities that facility might have, and care options that you're receiving through that facility above and beyond the necessities, right? And so care in our area can be, and this is our area that these figures are based off of, I should say, but care in general can be very expensive. Last week when we were talking about at-home care, you're generally looking at $25, $30, $35 an hour is kind of the range I see. And that can be very affordable for some people, but if you need care around the clock, it might be just exorbitantly expensive, and more expensive than you'd receive care in a facility for the same level of care, I mean. But even around here, when we're talking about assisted living facilities, you'll see anywhere from $4,000, $4,500 a month for the care on a low end. That would definitely be a lower end that I've seen. But if you or your loved one is going in for memory care related care, Alzheimer's, dementia, something like that, it's very commonly closer to $7,000, $8,000 a month for that care. So it can be very expensive even in assisted living. Now, skilled nursing tends to be the most expensive because it's the most in-depth, significant care need, but you're still generally looking at $9,000, $10,000 a month, right? As sort of a ballpark estimate on that. And those numbers can all vary depending on your specific situation. Of course, I'm just trying to give you general ideas on that, but it's based off of what type of care that person needs. So it can be very expensive, and being able to just pay for that out of income alone is very difficult for people, especially in retirement. There are certainly people who can do that, and that's phenomenal if you're able to. That's a great place to be, but not many retirees have that level of a disposable income. So a lot of people are dipping substantially into their built up retirement assets to help pay for that. So if that's a concern, if you wouldn't be able to privately pay for very long that way, or you just don't, you want to have something left over so that you can supplement your needs if you need to, and you're looking for other ways to cover those expenses, that's when we're generally looking at different kinds of long-term care insurance, working through your advisors to help you get connected with people who can help you find that. Because if you can't privately pay, a lot of these facilities are starting to require more and more so in longer and longer periods of time, 1, 2, 3 years of private payment before they'll let that person live in the facility on Medicaid. It's depends on the facility. It depends on how full they are. There's no rules around how long they can require that private payment in terms of, they're allowed to, and they're able to require private payment as long as they choose. Some facilities don't accept private payment at all. So in theory, when a facility accepts Medicaid, the reason they're not allowed to actually state what their private pay requirements are in writing is because if somebody accepts Medicaid, there isn't a period of time that they're supposed to say you should privately pay. But that being said, they still do. And so you want to be able to work around that and pay those facilities. But some facilities don't accept Medicaid at all if they don't have a contract with Medicaid. So being able to privately pay just means you have choice in where you get care, the location of that facility. Is it closer to the family that you'd want? Do they have the amenities that you would want in that facility? Do you have the private room or shared room, right? All of those sorts of things are factors when we're talking about private payment. But being able to meet the requirements of a facility to pay for a period of time is very important, because then you have choice in the matter. But if you don't have the assets yourself to do that, which plenty of people don't, then you're looking at other options to help pay for care. And one of the first things we recommend is long-term care insurance, as I mentioned. Long-term care insurance is different than things like, long-term disability insurance that you might get through work. Long-term care insurance specifically covers things like at-home care, assisted living care, or skilled nursing care. It usually covers certain daily amounts in costs for a period of time. 3 to 5 years is kind of the average of what I see. Sometimes less, though. It just depends on what that person can afford to pay for, right? And then it usually has a maximum payout amount. So it'll be this period of years or this amount of payment, whichever comes up first a lot of times. So looking into this is essential. At least getting the quote on it is very important, because if you don't look into it, you just can't make a good informed decision on whether it's the right tool for you. The worst thing in the world to do is listen to what it costs someone else to get, because that's very much so based off of their health, their age, those sorts of things. Get a quote for yourself. Maybe it is too expensive for you to afford, and that's okay if you have gotten that information and you make that decision at that time. But just don't listen to what other people are telling you it costs them, because it's kind of like listening to, well, this person's health insurance costs them more than mine is costing me because they have significant health concerns, or they've used their health insurance a lot more. They have like a family of 5 and I'm a single person, right? Whatever it is. So just get the quote. The ideal time to look at this is generally in your later 50s, early 60s, mid 60s at usually the upper end. You can look at it after that point, certainly, but that's just one of those things that it's going to be more expensive as you get older, and they can look at your health concerns as to whether they will cover you at all, or if it's going to be more expensive. So, there are situations where somebody with like Alzheimer's or dementia already diagnosed, they're probably not going to cover that person because they know they're going to need care. So look into it. It's a great option if you can afford it, and if it's the right tool for you. But if not, there are other options too. Tying into that, of course, is maybe you just have enough to privately pay forever and you don't need the insurance. You don't need to worry about Medicaid, and I have clients in that situation, and that's perfectly fine. I mean, that's a good place to be, right? Yes, it's expensive, but you maintain control over your care as long as possible. And this care is valuable. So I'm not knocking on the cost of the care. But it is just objectively expensive. And so it's good if you can pay for it though. But if that's not an option, if we're not able to privately pay for a client, or if insurance, the long-term care insurance isn't an option, that becomes a question of, well, how do I maintain control over this as long as I can? How do I be able to supplement this if I spend down through everything, I won't have the ability to do that. So this is often where people get confused a little bit about what programs pay for care, what like retirement programs pay for care. Medicare will not cover long-term stays at a facility. They cover rehabilitative stays at skilled nursing facilities, but even then it's only up to 100 days. And even for those 100 days, it's not the full value of it. And they will try to end that coverage sooner than the 100 days. They'll say things like, you're not improving, or, you're going to be here indefinitely, so we're going to just stop the Medicare coverage, and that's when you're privately paying. The other couple of programs that we do work with to help someone pay for care would be Medicaid as an option. And then for wartime veterans or the surviving spouses of wartime veterans, there's the VA's Improved Pension Program as well, which doesn't meet as broad of an audience, but it's still a very important thing to know about if you're not familiar with it and you are a wartime veteran, or your spouse is your surviving spouse, excuse me, of a wartime veteran. So for Medicaid though, in order to qualify for this, people have to spend down to a certain point. And I'll give you kind of a very quick overview, just because we're a little more limited on time today than if I were going to give the full detailed description. But in order to qualify for Medicaid as a single person, generally speaking, other than a few exempt assets, you're going to have to spend down to less than $2,000 in assets. And for the home, they can place a lien on the home as they provide care. Medicaid can. So eventually Medicaid will eat up the equity in the home. And this is where, by the way, when people talk about, I don't want the nursing home to take the home, it's not the nursing home doing that. It's Medicaid putting a lien on it, which it's related to the care, but it's not the facilities taking the home. So that's a lot to spend through for some people. That doesn't leave a whole lot for you to be able to supplement things that Medicaid may or may not cover. They cover the necessities, don't get me wrong, but they, I had somebody the other day, a client who mentioned that the facility had wheelchairs, non-mechanized wheelchairs, but their mechanized wheelchair broke down, and that wasn't something Medicaid was going to cover because the facility had these other wheelchairs available, right? So that's just an example of somebody having difficulties with Medicaid on that. So having money left over to supplement those sorts of things can be very important. A single person, they can only keep $45 a month in their income. All the rest of their income has to go towards the cost of care to supplement Medicaid's expenses. So, with supplementing your own care, $45 a month and $2,000 or less than $2,000 is not going to cover a whole lot. Now, a healthy spouse, the spouse living at home, can keep a little bit more in terms of assets. As long as they're living in the home, still their primary residence, and they don't need Medicaid assistance, that home isn't going to have a lien placed on it for the healthy spouse. They can keep their retirement accounts in their names, so IRAs, 401ks, 403bs, any of those types of accounts, they can keep in their name. The spouse's IRAs and 401ks do have to be spent on care down to a certain point. You can keep one vehicle, you can keep life insurance of not more than $1,500 face value total. Otherwise, they'll look at the cash value as an asset. And then you can also, as a married healthy spouse, keep anywhere from as little as $50,000 of all the other assets that are available for care, up to about $138,000 on the upper end. And how much of that you get to keep depends a lot on how much you have available for care to begin with. So they look at what they say is an available asset, they being Medicaid, and will calculate what you are allowed to keep as the healthy spouse based off of that. So that range depends, the more somebody has available, the more they get to keep up to a maximum. But if somebody's already below $50,000 total as a married couple and only one of them is in care, they're probably already qualified for or financially eligible, I should say, for Medicaid. So, spending down though, once you get beyond that point, and if you're both in care at some point, you're still back down to $3,000 as an exempt amount. It can be hard to pay for other things that you might need. So it's not a whole lot of flexibility if something comes up and you've spent through everything. So this is often where people talk about things like, should I gift the home to the kids? Should I gift things in general to the kids to help set aside money so that I don't have to worry about running out of everything? They have this money available. And there's a couple problems with gifting without talking with an elder law attorney first on this. The first is that a lot of people think there's a certain amount you're allowed to gift per year and not have it create a problem for Medicaid. What they're thinking about, what they're getting confused about, is that the IRS says you can file, or you don't have to file gift taxes unless you've gifted more than $16,000 per person per year. If you go over that per individual that you gifted to, then you have to file a gift tax return. But that has nothing to do with Medicaid at all. Medicaid doesn't care that the IRS says there's a $16,000 gift tax exemption. They say if you gift anything for, to your kids and it's substantial and, you could have used that on your care, then they're going to call it a divestment, which they then give you a penalty for when you apply for Medicaid if those gifts occurred within the 5 years before the application. So that's where people hear the 5-year rule for Medicaid. It's a 5-year look back rule from the date of application. So gifting, thinking you're getting around that 5-year look back rule can be very difficult if you don't know what know the rules specifically, or if you think that gift tax exclusion somehow applies to Medicaid. There are certain exceptions to divestments, but you need to talk with an elder law attorney first to know whether they even apply to you. And you don't want to rely on the internet to give you advice on that, right? Even if it's, a legal article, if it may be a different state that they're talking about, you want to talk to an elder law attorney in your state. So gifting can be issues for that reason, can also be an issue for maintaining control. So when we use the home as an example here, and that handout you'll get from us is a good example of this. But there are a couple of really big issues when people gift the homes to the kids. When they take their personal residence and give it to the kids, they deed it over to the kids, even if they're planning around the 5 years, even if they try to do it well in advance of that 5-year look back, needing to make that application, then there are still usually 3 big concerns that somebody might have. The first is that, one, we talk about maintaining control, right? Well, maintaining control after you've given your home to someone else is really difficult. The owner of that property is who maintains control of that property. So this is where you hear the stories of somebody, evicting mom or dad from their property or charging them rent. I mean, you hope that never happens, and it's not, thankfully, not like a widespread issue, but you do want to make sure that you maintain control and that somebody isn't, doesn't have the ability to do that to you, right? You don't want to protect your home from care just to lose protection for yourself. The other big issue is one of taxes. When you leave your home to your beneficiaries through your estate, they get the adjustment up to fair market value and the cost basis on the property, which means when they sell the property, the difference between the fair market value and that cost basis is minimal or non-existent. So they don't have any capital gains tax to pay. They don't have tax to pay on the sale of that home. If you gift the property over to them without them purchasing it for fair market value, they have a cost basis that you had in it, which your cost basis, if you're unfamiliar, is essentially, what did you buy the home for? What did you put into the home financially? What stake do you have in this? And then how they calculate the capital gains tax is the difference between what it sold for and what your cost basis was. That's a very oversimplified explanation of it. There are a lot of adjustments that can occur due to depreciation, improvements to the property, all of that. So, I'm oversimplifying it, but that's essentially a very easy to understand breakdown on it. But when you gift the property over to your kids, if you owned your home for 30, 40 years, there might be a lot of built-in gain there that you want to avoid paying taxes on if you pass it more efficiently. When you gift it to the kids, you're essentially just gifting them money that they're going to have to pay tax on at some point, a certain portion of it. So it's not the most tax efficient planning. But really the biggest concern I have when people put the home in the kid's name, and I was actually just talking with another attorney in our office about this today, about somebody that they had met with where this was an issue. When you gift assets, when somebody owns a property, when they own real estate, when they own bank accounts, right? Things like that, cash assets, what happens to them happens to the property they own. So if they are now owners of your home and they get sued, or they get divorced, or they file for bankruptcy, or they pass away, those things happen to their interest in the home. So you, as the primary resident of your home, it's your primary residence, you have some protections from, bankruptcy totally eating up the value of the home. They're not perfect, but better than nothing. You have, your kids' divorces don't impact you. Your kids passing away don't impact the ownership of your property. They impact you in other ways, of course. But your property is only subject to your liabilities as long as you own it. When you gift it to other people, you're opening it up to everyone else's liabilities that you've gifted it to. And there are safer ways to transfer that property. To give you an idea of why this can be dangerous, we had a family come and talk to our office because their parents had gifted the home to the 4 kids, 20 years ago or something like that. And in the intervening 20 years, it was time to now sell the property. 2 of the 4 kids had passed away, and one of the kids that had passed away left their share, because this is what their estate plan said, left their share to their son, which was the grandson of the original owners. Well, he is now 25 years old. He has a major substance abuse problem, and they're trying to figure out, how do we stop him from hurting himself with the money, right? How do we stop him from using it for that reason? And because it was his ownership by right at that point, there was nothing they could do to stop it. He had every right to take the proceeds of his quarter of the home at that point. So this was obviously not the intention of the original owners when they put it in the 4 kids' name, but it shows that that type of planning does not protect against these sort of unforeseen things. So when you're gifting things, you want to do it in a way that, when you're protecting assets, you want to do it in a way that isn't a concern. And that's often where we look at things like irrevocable trusts to do that, where you have the right to reside in the property as long as you continue to pay property taxes. Nobody can kick you out. You have, it's part of your estate, so it wipes out the capital gains concern, and it protects the beneficiaries of that estate from those sorts of liability concerns. And even more so during your lifetime, the liabilities of your trustees don't impact you or that home personally, right? So it's just safer to do that than it would be to just transfer it without any other planning in place. It's obviously not always the right option for people. It still counts as a divestment. So if you don't have the 5 years, there may be other things that you're looking at as an option instead, but it's something to consider. Just to talk a little bit, because I'm running short on time, about the VA as well. The VA's improved pension program for wartime veterans is a direct pension payment to the veteran or the surviving spouse of the wartime veteran. This is, it's more tied to income as well as assets than just Medicaid is. So really, as a wartime veteran, the maximum amount that somebody might be able to receive from this pension, which is tax-free pension directly to them, is about $2,400 a month. How they figure out how much of this pension that somebody gets if they're a wartime veteran is they subtract their income from the maximum amount of benefit, and then the difference is what they receive. So they're only getting you up to that point. But unreimbursed medical expenses, the VA deducts from what they count as your income. So for most people going into a long-term care facility, their cost of care, their unreimbursed medical expenses are higher than their income, meaning for VA purposes, you have $0 of income, which if you're a wartime veteran means you can get the full pension benefit. This is a really good tool to use if somebody is pretty close, especially on the cost of care. Maybe they're only about a $2,000 difference between their income and the cost of care. This could be a way for somebody to privately pay forever, where they never have to go on Medicaid or never have to give up control over assets or anything like that. It can be a really nice tool. So it's definitely something to consider, and talk to an attorney who is certified by the VA. Not just any attorney can plan around this. They have to be approved by the VA to do this. They can give you advice on whether you qualify or not. Now, the wartime dates are not always what people expect. Sometimes people fall in between the wartime periods, especially right now in relation to in between Korea and Vietnam. I have a lot of people that are in that gap, so they are not qualified as wartime veterans, but talk with a VA certified attorney so that you can look into that if it's a concern of yours or possibly an option. And then just one last thing I'll leave you with too, just because I am really running close on time here, it looks like. You also want to not just plan for the current person going into care, but also plan around what happens if you as the healthy spouse pass away first. If you pass away as the healthy spouse and your surviving spouse is still in a facility receiving Medicaid assistance, the amount that they were allowed to have when you're the healthy spouse that you were allowed to have safe from their care changes completely when you pass away, and they're still only allowed as a single person to have those $2,000 in assets. So if you have money left over for yourself that you leave to them, that can create, they can lose their Medicaid eligibility until it's spent back down. What you can't do is you cannot disinherit that surviving spouse either. So that's not like giving you license to go say everything goes to the kids and circumvents the spouse. That will also count as a divestment when that occurs, and will kick the surviving spouse off of Medicaid at that point. So there are other planning options you want to do, and talk with an elder law attorney on getting in place for yourself. If a loved one is currently in care, your spouse is in care, and you're looking to make sure that, hey, if something does happen and I pass away first, that they're still protected, that they're not harmed by that in any way, and make sure you're doing things the right way. So there are options for that. And we'd be more than happy to talk to you about those options. If you want to set up an initial consultation, like I was mentioning earlier, you'll get that feedback form from us. Please let us know by filling that out if you'd like us to reach out to you. Those are complimentary, like I said, scheduled for about 2 hours. And we ask for quite a bit of information, but it really does help us to get a better recommendation to you then. Like I said, next week our topic is up north planning. So planning for the family property, whether it's a cabin, cottage, hunting land, right? Whatever it is. So if you're interested in that, please sign up for that as well. And otherwise, everybody have a great Labor Day weekend, and enjoy hopefully